Hello, my name is Zach McGee. I am the chairman of New Media Legal Publishing, the sponsor of the CLE program you are about to watch. This program was recorded a few years ago, but we've confirmed that the content is still current and reflects the present state of the law on this topic. I hope you enjoy it.
Hello and welcome. I'm Peter Afrasiabi. I'm an intellectual property litigator at One LLP. We're an IP boutique in Southern California with offices in Newport Beach and Beverly Hills, California. Today's program is IP due diligence in corporate transactions, lessons from litigation. And so what we're going to be talking about today is for you as IP transactional lawyers, as general transactional lawyers, as corporate transactional lawyers, and as general practitioners, we're going to be talking about the IP issues that you need to be looking at when you are doing a checkup on your clients, when you're trying to get their assets scheduled properly, when you're engaged in a transaction. And we're going to look at it through the prism of litigation where these things have gone south. And so up front, I'll tell you, I've litigated many of these cases. Our firm represents small businesses, large businesses, publicly traded companies. We are on the plaintiff side, we're on the defendant side, we're paid hourly, we do cases on contingency. We're on all sides of litigation cases in this IP realm. And as a result, we're a true boutique in that sense. And that has given us insight into these cases on each side of them and where things can really go south on the front end in the transactional process. And so this program is built and designed to protect you so you don't end up coming and trying to hire someone like me or being sued by someone like me. So let's get focused here on what we can do to protect your clients and the lessons you can take. As you see on the next slide, we have a picture of, copyright, trademark, patent, and trade secret. And these icons on this picture are really designed to focus you in on the fact that we will be today exploring these four different areas of intellectual property law. And these are fundamentally the four areas of intellectual property law that afflict corporations, in which corporations transact, they deal, they do business in. These areas of the law intersect with corporations regularly. And so we will be looking at these areas of the law in these four different modules today: copyright, trademark, patent, and we'll end with trade secret. So what are the major issues that we are going to assess today? We will look at what kind of assets are these IP assets. What is a copyright? What is a trademark? What is a trade secret? What is a patent? What kind of an asset is it? And what you will see is it's counterintuitive to our normal understanding of what assets are. Our general understanding as lay lawyers, so to speak, as just general lawyers, can be very, very different to what intellectual property law says. And this is really occasioned by the fact that if we go back to law school and we remember, there's no requirement to take IP law. Remarkably, we had to take real property law, but we didn't have to take IP law. And the principles and ideas and even concepts that undergird real property law often simply don't exist in IP law. And so this can create confusion and lead to mistakes ultimately that we see. Hence, we'll ask the question, does the person who paid for it really have it? Seems like a silly question. If I buy a car or a piece of real property, title gets transferred, I own it. Not always the case in intellectual property. And so this is a very important issue that we have to look at too, to keep you aware of, so that as you go through this program, you'll get some checklists in this program for you with these tips in terms of what to do. You want to keep track of them. The other thing we want to look at is that by understanding better these four areas of law, you can figure out whether your client may have assets it doesn't even know about, or it could have the potential to create assets, such as patents, that it doesn't think it doesn't think it could get, but maybe it could. And so they could be leaving assets on the table that they don't need to leave on the table. We will also discuss whether these assets, these IP assets, have been registered. If they have been registered, were they registered properly? If they weren't registered, can they be, should they be, or do they even need to be? It's not the same for these four areas of law either. So the next point we'll look at is sort of an evidentiary documentary type concept, which is as you're going through your client's records and books and transactional history, there are important different facts and evidence and types of things that you want to find, you want to preserve, you want to control and protect. If that asset is ever to be litigated or enforced in any way, this material could really help. And if it's lost, it could be lost forever, and it could damage the value of that asset once the asset gets put into litigation, which is often the place that ultimately decides what the asset's even worth. And of course, throughout the program, you will get tips and checklists for your IP due diligence asset search process that you engage in with your clients. So let's get turned now to our first module, copyrights. We're going to do a brief overview of what copyrights are so that you know where you're going to parachute in as we get into the details of how this plays out in transactions. And then we'll look at how this has sort of created problems and ill effects for companies in litigation. So a copyright protects an original work of expression fixed in a tangible medium. There's a very low bar to originality. It's only the idea that it must be original to the source with a very low threshold of artistic creativity. Quote, a minimal degree of creativity, extremely low, end quote. That's from the US Supreme Court in the seminal case of Feist, 1991, but it harkens back a century earlier to 1903 in the Bleistein versus Donaldson Lithographic Company case. And this is a statement of the law from Justice Holmes, and it underpins copyright law in 1903, it underpins copyright law in 1991, and it underpins copyright law still today in 2021. It would be a dangerous undertaking for persons trained only to the law to constitute themselves final judges of the worth of pictorial illustrations outside of the narrowest and most obvious limits. At one extreme, some works of genius would be sure to miss appreciation. At the other end, copyright would be denied to pictures which appealed to a public less educated than the judge. That point's critical, and what it tells us is it doesn't have to be a Picasso to be copyrightable. And so there could be all manner of creative works created by your clients that aren't novels and books and paintings and these amazing works of art that we go look at in museums, but they could still be copyrightable and they could still have value as a copyright asset. Doesn't require a massive degree of creativity. The other point to understand for your clients is that if they are creating works and they're borrowing from others because they think they can, because they think it's public domain, because they think it's fair use, the major point to understand is when you're doing an IP due diligence checkup for your client in that context is that fair use is really hard to win on for a defendant who's charged with infringement. If you want to justify using someone else's creation, it's incredibly hard to win at summary judgment on fair use. It's often the type of inquiry that becomes one for trial, which means it's incredibly expensive to litigate to the end. It creates massive uncertainty, and litigation and uncertainty equals a lot of expenditures going out of a company. So this comes up a lot. We've seen in the context, for example, of your clients may be creating websites and they're putting up contents and photographs to help tell a cool, flashy story about their business. And they take the photographs from somewhere on the internet, or they think it's public domain because they got it on the internet. Of course, not public domain just because it's on the internet. But even sometimes there are sites on the internet saying public domain, and the stuff there is not public domain. You can't even trust that. And so that becomes a context where this comes up a lot, where people end up absconding with something that's not theirs. So the big question you're then asking your client when you go in, all right, well, what is it and do we have it? And copyright exists at the moment of creation. There is no registration requirement. So your clients may never have registered a copyright, but that doesn't mean they don't have one. And so for this reason, many people don't realize they actually have copyrights because of the assumptions that people make about a registration requirement or a brilliance requirement, like amazing creativity. So what should you be thinking about when you're going into your small, medium, big business and you're kind of thinking about copyrights and due diligence work? You should be thinking about software. Yes, software can be copyrighted. Manuals, written work products, artworks, photos, these types of creations that your clients are making to market and sell their business, to pitch, sales techniques, these types of things, software to run their platforms that they provide services on for other clients. All of those things can be registered with the Copyright Office. All of those things can be copyrightable because they are at the moment of creation, and so copyright inheres in them instantly. But they can also be registered. And so if they have not been registered, you want to advise your clients and be aware that there could be a great benefit to registering. Registering a copyright allows you to get better damages and your attorney's fees as a potential remedy if someone infringes the work after you've registered. And it's required to sue in court anyway, so if you ever think this is the type of content that you would want to sue someone over if they took, you may as well register. It's very cheap, $50 odd. You can get your copyright registration certificate, and then you're protected both in terms of having standing to go to court, but also ultimately on the remedy side to get a much better remedy, which means that asset that may have a market value of $500 in litigation could be worth $5,000. And so that means your client's asset now has more value. The question, though, is who owns it? Who owns this creation? And this is where we have our first disconnect with real property law. Ownership is different under copyright law to normal property law. And so this requires a lot of caution and a lot of digging to get to the bottom of transactional documents so you can ferret out and figure out who owns it. The central rule that you should keep in mind is the person who pays for it doesn't necessarily own the copyright to it. And so this comes up for businesses all the time in the context of employees and independent contractors. And there are huge implications for a company creating content as to whether the creator of the content was an employee of the company or an independent contractor of the company. Under copyright law, an independent contractor owns the copyright in the work they've created for the company that hired them to create the work, even though they've been paid by the master for the work. In order for that master, that employer who's hiring the independent contractor to get the copyright to the work, the independent contractor has to assign it in a written assignment document. That's required under copyright law. And so if you don't do that, that means that independent contractor still owns the copyright. Your client will certainly have a license to use it, maybe an exclusive license, maybe not. Depends on what the circumstances were at the time, of course. But you won't own the copyright. And that can become really important because if you don't want this work product recreated for someone else, then you want to own the copyright. You want to make sure that independent contractor assigns it over. And if the copyright becomes really, really, really valuable one day, and then you want to sell your company because now you've built this little company up into something massively valuable, and the crown jewel is your software, for example, and you own it, and then you go into diligence and it's found out that maybe you don't own it because the independent contractor actually owns it. That's a difficult conversation to have with your investment bankers, with the side looking to buy your company on the diligence side. And it's awfully awkward and difficult when that independent contractor finds out about it and now knows he or she has a very valuable asset. On the other hand, and by the way, these are real stories, these aren't hypotheticals. I've litigated those cases. I'm going to talk to you about it in a minute, that exact case. On the other hand, an employee, a traditional W-2 employee, that work product that the employee creates is owned by the company at the moment of creation because the company is deemed the author of an employee's creative work. And so this is a critical line to be aware of in terms of whether someone was an independent contractor or a W-2 employee. It's a line that often gets missed because when we talk to our clients about, in the diligence process, about, did the people who created it, were they employees? Clients often just perceive no difference between contractor and employee, and they say, yeah, they're all my employees. I employed them all. But maybe they were, maybe they weren't. So you need to know how to peel that onion back to ask the right question to go deeper. So let's get into that litigation example. And here we have a small startup software company. It's building telecom software in the early 2000s, and it's just a few guys in a garage, and they're building some software. They hire some independent contractors who create sort of the sort of embryo code that's necessary to build this telecom software. And the company grows and grows and grows over time, and those independent contractors eventually become employees actually of the company and are now paid as employees to continue building and creating new modules for the software. But the earliest part of that software was actually built and paid for to an independent contractor. And when those independent contractors came on board, they didn't assign the copyright or sign any assignment, so they technically still owned it. Then you can fast forward decade plus, and the company is being acquired. There's been a change of management, change of ownership over the years. The original founders are out, new people have it, and now all of a sudden they're going to cash out for big time money. And the original independent contractor, no longer at the company, learns about this, knows copyright law pretty well, and realizes, hey, wait a second, no one's going to pay 8, 9 figures when I own the copyright, and so I can get my beak wet and get a piece of the action. And so, as happens in cases all the time, this happens. It's now three-way piece of multiple party litigation over ownership. Title has to be cleared up for the company if they're ever going to sell. They're under pressure. They have to end up paying. Money changes hands, as you can imagine, in a way that would never have happened on day one if the company had known when it was starting up, get the person to sign an assignment of copyright. And so this is the key lesson. I mean, it's many times you may be representing small startups and they don't have money to hire lawyers. They're doing things on their own. But at a minimum, you can tell them, hey, even if you can't afford to get me in there and to make sure you have a clean bill of health and you're doing things right, just remember to tell them, You're paying someone $5,000 to build you some software. They're going to build it and you're going to give them the $5,000. Have them sign an assignment document. It's a paragraph long. They're very standard copyright assignments. We do them all the time. Very easy to do. It's even cheap for them to hire you to do it. But get them to do it. And all the time, the independent contractor will sign it. They just want to get paid their $5,000. If you don't get them to sign it, you'll do the same transaction potentially down the road, but it's going to have more zeros attached to it. And so that's a problem. And so the point here for you when you're looking under the hood and doing this diligence analysis is that there really is embedded risk in the asset value. You may be looking at something and thinking, great, we have all these assets that are worth a lot. Let's make it public that we're selling and the word's going to get out to everyone. But if you don't really own them, people are going to come knocking on your door. So you want to clean up that first before anyone knows that any outsiders know there's real value there. And so key point, don't assume copyrighted works are owned by the entity, even if they've got the little copyright symbol on them and they say they've registered them and all that. You need to dig deep to make sure you know who created it and what was the status of the creator at the time. So here on the next slide, you see some of our copyright questions that we need to ask. Was the work registered? If it was, you want to get all the records from the Copyright Office. You want to check the status. You want to understand exactly what was registered, what it said, what wasn't registered, what was deposited with the Copyright Office. It's often the case that someone may register something, they may call it, manual, and they tell you, yeah, it's this manual. But it turns out the manual they registered was actually this manual, totally different manual, which means your copyright attaches to something else, not what you think it does. You need to know what was the deposit material given to the Copyright Office with the registration. If there are no registrations, then figure out, is there stuff here that we could register for a small amount of money? Let's identify any of the creative works, remembering it's a low bar, any creative works, any content that could have value to this company, how they do things, what they do. Once you understand how that business operates and how it transacts business, you can quickly identify where there is content, copyrighted content, that you may then want to attach a registration to. Figure out who the employee independent contractor is. Are there assignments in place? If not, get them. Employment agreements. Look at the employment agreements. Make sure you have the right employment agreements. All of you know what they are in your various jurisdictions, but you want the right language in your employment agreements, making sure that inventions and know-how and creations belong to the employer and only the employer. If there have been actually historical copyright disputes involving any copyright assets, get the letters, get the litigation history, get the statements of the parties, because all of those can greatly redefine what the scope of that asset is. And so you need that record, you need to look at it, you need to understand it so you can really know what's going on. And then, are there copyright licenses for any content being used? And these are licenses that run both ways. If you've licensed it out, you want to understand what those licenses say so you can understand what rights you still have, what rights you've given. If you are licensing others' copyrights, you need to make sure you understand the scope of those rights and make sure that you don't exceed it. It's often the case that small startups will license some content for a particular purpose, and then they just know, oh, we licensed this photograph, we can now use it. And then they start using it in 100 different ways, which is way beyond the license and leads to liability. That's our first module. So now we are going to shift to trademarks. Here we see our trademark slide. Trademarks are symbols, words, phrases, colors even, all of which denote a product or service's origin from one entity and they distinguish it from others. They must be used in fact and commerce. Something generic cannot be a mark, but something descriptive can be a mark if it acquires secondary meaning. And so that's the high-level overview. We'll get into more detail about what all that means, but the basic premise here is to be thinking about, from a trademark prism when you're looking into a company's assets and doing diligence into a company, you want to be looking at what are the brands they use, what are the slogans they use, do they have a particular color combination that they may have put on a product or they may put on their marketing or their advertising, a unique logo, those types of things. Think of it broadly. Things that the company uses to distinguish them and their products from others as they communicate to consumers. Those things that mediate the relationship of the company and the consumer with respect to the product that's channeling in that mediated relationship, whatever attaches to it, that's kind of the brand that you need to be thinking about, and those are the things that you want to be looking at that could be relevant from a trademark perspective. And as we note here, they can be really broad. It can even be colors in certain contexts. So let's get more detail here. What are trademarks? How do they work? Do we have any? And so, of course, you have to be thinking about logos and taglines and company names, and even website look and feel can be a trademark. And so you see here some pictures on this slide of, there's a picture of a pill. That color combination of the pill can itself be trademarked, such that the manufacturer of that pill can control the use of that color combination, the clear with the colored dots and then the red cap on it. That can be controlled because that could be distinguishing that pill from other pills. It can also be, you see on the right side there, a picture of the inside of a restaurant. That's the famous Fuddruckers restaurant. I don't even know if they're around anymore, but they were around in the 1980s and 90s when this case was litigated. And the look and the feel of Fuddruckers, the entire look and feel of the interior of the restaurant was very unique. The way they put together the colors, the wood, the signs, the stations, all of that made everyone know when they went in, this is Fuddruckers. You can also think of TGIFs. You go in there, each TGIF has a very unique look and feel. They're all the same. That whole look and feel with the red and white swivel lines even in the dark wood functions as trade dress. It's telling consumers when they go in, this is associated with a brand, with a company behind it. That brand is TGIF. And so when you're going in, you want to think beyond then, as a result, mere words or phrases. You can't just find out from your client, do you have a tagline? What's your signature block? What's the name of your company? Okay, trademark, done, move along. Can't do that. You want to go deeper, and peeling that onion back deeper requires you to think about this trade dress. And this design and appearance of a product like we saw in the pill, or the packaging of how a company looks and delivers its appearance to people, such as Fuddruckers, that overall image can be protected as a trademark. It's known as trade dress, but that's just another way of saying what we commonly understand as being a trademark or a service mark. And this serves to identify the product being presented to the consumer. And it even includes retail stores or websites even in this day and age. And so you see there in the picture, in the middle, a picture of a website. And that's a case that's been litigated in the courts over a unique combination of elements that a court held could, at summary judgment, constitute trade dress. And it is this unique combination for a particular type of product or service. There it was sort of women's pregnancy services and goods. There's a certain color combination that was used. Certain model shots were used, always taken at a certain angle with certain props in the background. The font was of a certain kind. Things were organized in a certain way. And so the overall look and feel of the website was sort of itself identified with someone, such that if someone replicated that whole overall look and feel, it could create consumer confusion and you would be on a different website than the one that you thought you were on. And so that can constitute a trademark too. So as we did with copyright, let's ask the question now, is there a registration requirement? No, there's not. So this is really, really important. What this tells you is that when you're going in, a client may tell you, yeah, I don't have any trademarks, because they may be thinking there's a registration requirement. They know they've never registered anything, so they tell you no. And so you got to dig deeper and figure out again, what are they doing? The absence of registration doesn't matter. Trademarks exist at the moment they are being used in commerce and affixed to a product. So registration doesn't matter. If they're using it in a certain way, it can be a trademark. Now, there could be, and there are, huge benefits to registering your trademark if it hasn't been registered. And again, it's relatively inexpensive. And if you have them, you can have access to better remedies in court with the registration. You can have better control over others ever encroaching upon your brand or your mark in different geographic regions or different content verticals or spaces that your company may be operating in. It gives you wider protection and a wider berth. And so there really is an important benefit and use to it, especially given the cost is relatively cheap, both in PTO fees and even legal fees. It doesn't cost that much. And so if there are registered trademarks, you should check the U.S. Patent Trademark Office database to see if they're there, make sure they're current, make sure they haven't been abandoned, make sure they've filed all the requisite filings, statement of continued use filings and the like that are required, a certain time after a trademark's issued. You want to check. The other place you could check is state trademark databases. States are able to issue state trademark registrations, just like the federal trademark. It's a regime of dual intellectual property protection. So many states, California, for example, has a state trademark registration database where people can register a trademark with the state only. If they, for whatever reason, only do business here, they don't want a federal one, they can do that. You want to check to make sure maybe someone did that. Often the case, it turns out in my experience, that companies have no federal registrations. They have a state registration, but current people don't even know it because someone way early on registered something with the state, it got lost, it got forgotten, it didn't get scheduled or put anywhere, and there's this sort of pending state registration out there that people don't think to go look for because when they think to go look for trademarks, they go to the federal database. So think state database too. And then when advising your clients and looking at what types of marks or slogans they're using, you want to think about the difference between TM versus the little R with a circle around it. And you use TM if you are using a mark as a trademark, but it's unregistered and it hasn't been registered. But if you have registered a trademark, you can put R with a circle around it and put that up against the end of your little trademark. And that's a good thing to do. It's not mandatory, but it's good to do it because it puts others on notice that this mark is actually registered or that it's being used as a trademark. So there's constructive notice that you may be violating people's common law rights, for example, and it becomes harder for people to get out of willfulness charges if you're in litigation. Which brings us to our litigation example. And so this lesson, we're going to talk about what often happens in companies as they grow and what we've seen on the litigation side when you have small companies getting bigger and bigger. And so this is a prototypical type of case we've litigated. I'm not going to tell you who the parties are, and I'm going to talk about it at a high level, but I've seen this in other cases. I'm in reported cases. I've just seen the other cases, and I've litigated one of these cases myself. And so one of the things that happens often is small companies get bigger and bigger. They bring in in-house lawyers, and one of the first lessons that in-house lawyers, especially if they have no experience in IP, one of the first things they hear when they start talking to people about, what do we do, IP, what do we do, is they're told, oh yeah, you got to patrol and protect your IP. If anyone's infringing, you got to issue cease and desist letters. Otherwise, you could lose rights. So patrol, enforce, patrol, enforce. And what we have seen before is, young lawyers come into companies and then just start, boom, rattling out cease and desist letters and charging people who are using similar marks with infringement. And that is okay to do, but one needs to use extreme caution in the race to charge infringement against third parties now that you suddenly have some money, some funding, and you want to make sure that you sort of do this rapid land grab to protect your terrain. And this then is the story of charging too fast, too soon. And what happens in this example is company gets really big really fast and it's got a brand. We'll call it X. It's a great brand. It sounds really great and it wants to control it. And all of a sudden it's gone from being small to massive, almost overnight, and suddenly got lawyers, didn't have in-house lawyers before. Suddenly they're rattling out cease and desist letters and rattle out a cease and desist letter saying to a very small company, you are using X, because they've gone and researched and they found, hey, there's some company using X. They're not allowed to use it. We're X. Shoot off a letter. And in that letter you say, you are using X. Your use of X is creating consumer confusion. Anyone is going to think that you are us because we're each using X and it's the same. So you have to stop because you're damaging us in the use of X. That's an X, of course, is just you pick the brand. Little company gets that letter, goes to lawyers. Lawyers look at it, go do some diligence, some research, and find out, wait a second, this little company using X was using X before big company ever existed and has been using X the whole time. It's little and below the radar. And so what you then immediately realize is big company has launched this letter off to the wrong person. The person they sent the letter off to is actually someone who has superior trademark rights to the big company and who can actually profoundly damage the big company's control of their intellectual property. And so this is an example of you launch too soon against the wrong person, and now you actually, that launch, it's a boomerang. You've now jeopardized your own IP, and now you're involved in a negotiation with lawyers on the other side who are representing the little company who are saying, you sent a letter saying that we're both the same using X. We agree, and we agree it's creating consumer confusion. But we're the senior user, you're the junior user. And you've now almost put yourself in an estoppel position on even saying that there's no confusion now that you're a defendant. You've gone from being plaintiff defendant overnight. And what you're doing is writing a big check to buy out that little person's mark and get it. If you had never sent the letter, you could have approached them in a different way and it would have been a very different transaction probably. It would have been a lot cheaper and a lot less risky. So it's a good example of before ever sending cease and desist letters, do a lot of diligence, do a lot of research, and be very careful. And you will often find actually when you go to IP boutiques, many times IP boutiques aren't interested in getting in the business of issuing one-off cease and desist letters for clients. practically speaking, there's too little money in it and too much downside because it's very hard to get your arms around who truly is first in the space. You can do even trademark analyses, go out and search, and you can still miss something. And so it's an awfully risky proposition for a very small return. So often you'll find small, very experienced boutiques don't even engage in that business for this very reason. They've seen how things can go wrong. They don't want to participate in it. But you want to be careful if you're going in-house or you're working in-house with a company and helping them build up. You want to be careful advising them to go do this because it could boomerang around. So get IP lawyers in there is probably the best advice to figure it out. There's complexity also to the infringement test. Just because someone's using something similar or the same in a totally different space or even in a related space doesn't per se mean there's going to be infringement. And so it's not a sort of strict liability regime, more like perhaps you could think of copyright where if you Xerox something or you reproduce something or you burn a copy of the DVD, it's copyright infringement done. Trademark's more complicated to figure out whether there's infringement. It's not just, are they almost the same? Is it substantially the same like in copyright? Here, the question is looking at a multi-factor test, and the multi-factor test isn't simply are they similar, therefore we end the inquiry. And that high level, you can think of the copyright test like that. Substantial similarity, case closed, move along. Here we look at multiple factors. And the multiple factors we look at here, and this is the formula from the Ninth Circuit, but it's a very common formula. All the circuits have a similar test. We look at likelihood of confusion. And this multi-factor test looks at the strength of the trademark. Is it something like Google that's just arbitrary, or is it intellectual property lawyers, which is generic, or is it something in between, Sentinel IP, which is kind of suggestive of being protective. Maybe it's a mark, maybe it's descriptive, something in between, right? We look at the strength of the mark, which is its own analysis. We also look at the proximity of the goods. How close is this? Is someone using the mark for coffee mugs and someone else is using it for shoes? What's the proximity? We look at the similarity of the marks. How similar are they? We look to evidence of actual confusion. And so this is important. Have there actually been any people who have ever been confused by this? If there have been, that can help tell you that there's likely to be confusion. If there have never been any people who've been confused, that tends to imply that no one's likely to be confused by the two, and so there may not be an infringement case. And this also gets tested, all of this, by experts. What are the marketing channels used? i.e., how are you mediating your relationship with your good and service with the end consumer? Is it through the internet? Is it through radio? Is it through television? Is it only through the yellow pages and then someone else is only on the internet and the two would never cross because they're always speaking to completely different channels of people, for example? Those types of things go into the inquiry. The degree of care by the consumers who purchase a product is really important because that illuminates whether people would be confused. For example, at the checkout stand of the grocery store, a pack of chewing gum, it's only 59 cents or 99 cents, whatever it costs now. And people are able to be confused. I mean, you may see something that looks like that kind of color and arrow on Wrigley's, and you see it, you pick it up, you buy it, you think you're buying Wrigley's gum. Turns out you're buying a knockoff. Why is it easy to be fooled or duped? It's because it's 59 cents or 99 cents or $1.29 or whatever it is, and it's just at the checkout stand, you pick it up, you go. You don't use a lot of care as a consumer, and so similarity in marks on products like that can have a greater propensity to cause confusion and hence lead to infringement. If you're buying a Ferrari, on the other hand, far harder to be confused into thinking that this car you're buying for $25,000 is, that says on it Spider is really a $300,000 Ferrari, right? It's just much harder to be confused. Not that I'm telling you to go out and create carbon copies of Ferraris, because if you've done my other program on trade dress for Ford versus Ferrari, you will have learned that one judge agreed with what I just said, but two judges said no, and the little knockoff lost. So what are the trademark questions you want to ask when you're doing diligence? Well, you want to find out, what are the marks you're using? What are the marks your competitors are using? Who was first in the space on what? Who has registered marks in this space for these words? Who has registered marks for these words even outside the space to understand what categories they're in and what their breathing room could be? And to do that, you need to go to the USPTO's trademark database and search it. For unregistered marks, you want to understand what are they being used on. And you want to get a listing of them from your client so you can assess what you need to register. What are we using exactly, on what products, and how does it line up with our registration certificate? And this is really important because one of the things that happens in companies of all sizes is the marketing and product people create a product and a brand. And time one, the brand sits on the product and the product is, something, the brand goes with it, and it's then registered as a trademark for this product. The trademark's registered, everyone is, boom, the lawyers did it, it's off, it's done, whatever. It's in some database somewhere, right? Time two, the product's changed, and the product changes again, and it changes again. And by the time you get to time five, you have a product that's still using this trademark, but the registration itself has nothing to do with it. I mean, you may have evolved into all sorts of other categories of spaces. And so when that happens, you want to be doing as part of your diligence a checkup to go find, okay, well, wait a second, we have evolved. We need more trademark registrations to get broader room on the evolution. You need to ask your clients, has there ever been any consumer confusion that's been reported to us? Complaints? People may return product to you thinking it's you, but really it's someone else, or they're returning someone else's products to you or your product to someone else. You find out about it. That type of consumer confusion is very important to preserve and maintain because it's evidence that experts can use to help illuminate ultimately why someone else is infringing on your mark, because consumers are actually being confused. Has there ever been a litigation record? And by this you have to be very clear, not just in court, but even letter demands, because letters can greatly shape the contours of a trademark by having statements in them by your client or your client's lawyers that can act as judicial estoppels or admissions about their marks and what their marks can do. So you want to get those. And then finally, you want to ask about intellectual property licenses. Do they have any trademark licenses? Have they licensed the mark out to anyone? And this could be informal. It doesn't have to be some formal, we got a lawyer, we did it. Maybe they just told their friend, oh yeah, you can use my tagline for your company. It's totally cool. You're my friend, you're my brother-in-law, whatever. Yeah, I use the brand. You now have a license of, an oral implied license that has some set of perhaps unclear terms to it. You want to understand if those exist so that you can bring clarity to terms and limit those terms to best preserve the asset within the company. That's our trademark module that you've now heard, and you've heard the scary trademark litigation case. So these checklists and these points, at least on trademarks, as with copyrights, can help you make sure when you're doing diligence, you're doing work, transactional work for your clients, to make sure that your client is fully protected on the trademark front. Now let's shift to our third module. We're going to talk about patents. Patents protect new, non-novel, non-obvious functional inventions. And this is what's known as a utility patent. So it's just got to be new, novel, and non-obvious. Ornamental, non-functional designs can also be protected, and these are design patents. And so there you may think, something that is now not functional and is entirely ornamental and it's got a design flourish to it can actually get a design patent. And it's sort of in some sense the inverse of a utility patent, because utility patents are protecting things that are actually decidedly functional in a new, novel, and non-obvious manner. Now the standard for patents, and you see there a picture of a very early patent of a camera. It's sort of, when cameras were invented, it was a big deal, obviously. But that's not the standard for a patent. A patent doesn't have to be some sort of Einsteinian brilliance, some sort of breakthrough that's going to change the world and therefore you can patent it. But your other inventions that your clients are making are like, yeah, they're humdrum, it's not worth anything. That's not true. And this is where the patent prosecutors in my law firm have found many times when they go in and they speak to small companies and startup businesses and even mid-sized businesses, when you speak to the engineering departments and those who are actually on the front lines inventing and creating different products for companies, they all think of what they're doing as being no big deal. We're just, building on existing things. It's no big deal. It's nothing special. When really often what it is very, very special, or at a minimum, it's patentable. And so that huge disconnect can exist, and it does exist in small businesses especially, between what is patent eligible and patent worthy and what they're doing. And many times they feel that their creations are not patentable, but really they are. And so the major lesson you want to deliver out of the gate to folks is that, look, your own preconceptions about what may be patentable, put them aside. Let lawyers come figure out for you what can be patentable, because what can be patentable often is simply a combination of a variety of elements that can all be pre-existing. But you put them together in a way that they haven't been put together, and that combination can become patentable. And that's really what most patents are. They are combining pre-existing things with some perhaps new thing or in a new way or with a slight addition or tweak into something that's new and is potentially patentable. That has to be educated and taught and ultimately learned by small businesses. Now let's look at them and figure out what they are and do we have them. And here we now pivot. In the realm of trademark and copyright, you only have it if it's if it's been created or done or used in some way. So you create your content, you create your trademark, you have it. In the patent side, creating it doesn't just give it to you. So you may have created an invention and you may be using it. You don't have a patent. You only have a patent if you apply to the federal government, you negotiate the process with the federal government, what's called patent prosecution, and you get an issued patent on a set of particular claims. This is language that defines the metes and bounds of your patent, so to speak. Then you have a patent. Until then, no patent can ever exist. And so this is where patents are different to copyrights and trademarks or other major areas of intellectual property law. Now, if you find when you go into your company you're doing diligence on that they have patents, that's great. What you need to do is get to the bottom of what's the realm of those patents, how many do we have, how much longer do we have on the life of the patent, have they been licensed out and all that. But what you also want to ask your client is, do you have an open family? Because an open family is very important. From a litigation perspective, if you're potentially to be a plaintiff because your patents are valuable, that's why you invested in getting them, and others are out there trying to infringe you, your client wants to have an open patent family because then they can continue to amend and update their patent with potentially reaching back to a date further back to deal with new infringers that come along. And so open families are one of the things that patent prosecutors, in my experience, give advice to small companies on, are to try to keep a patent family open so that you have that capacity to continually get new patents and create new inventions and have early dates if it's within the subject matter and you can fit within the specific patent criteria. But closing a family just because you want to close it unnecessarily is something that can then close off your ability to actually augment the asset value from the patents. And so the tip is have them keep patent families open if they can, because that certainly can have value and potential acquirers see that as value too, is what we have seen in litigation, of course. Now, the other thing you want to talk to your clients about is the difference between utility and design patents. And they may well have things that are functional that they're creating, maybe a new camera system or whatever that would be utility patents. But the very thing they're creating may actually have a unique design that itself could be protected by a design patent. And so the most famous case that you can think of, I'm sure all of you watching this program have heard about it, is the Apple-Samsung litigation over Apple's design patents on the look and feel of the iPhone. And that was really just a design patent on that kind of rectangular or so shaped phone that's glass covered, thin metal bevel edge. I mean, just the look and feel of an iPhone, right? They got design patents on that. And that specific look and feel then was protected by design patents, it was enforced by the courts, and it was a legitimate design patent on the look and feel of the phone, which itself can give you massive protection against others who come along and may want to infringe to create a product that looks very similar and is evocative of what your client is doing. And so there you want to be thinking about design patents for your clients, and you want to be doing inquiry into whether anything they're creating, if it has a commercial advantage because of the way it presents as well as what's going on the inside, you want to get patents in both. The same way, of course, Apple has patents on the stuff going on inside the phone that we don't see and none of us understand how it works, but they have patents on it, or in some parts of it for sure, but also in the part that presents to consumers that can be a design patent. Now, you have to file that patent within a year of offering for sale or selling the product. So if your client has something that they think is going to be good and they want to go start showing it at trade shows and getting early sales or early feedback from potential customers, they need to be very cognizant, and you need to be very cognizant of advising them to be careful about what they release and when they release it, and to make sure that they then get a patent on file within time. Otherwise, they are forever barred from seeking patent protection. And so when they are releasing or showing or selling new things, products to customers, figure out if it's patentable and make sure they're talking to a patent prosecutor to get it filed on time. The next aspect to this, and this is where there's often a disconnect, I think, when diligence is occurring in small businesses, is understanding really the scope of what a patent is and what a company has. And oftentimes you find companies themselves have patents, and the patents don't even cover what the companies think. And that is because the patent prosecution process is so complicated and cumbersome that where someone starts is often completely different to where they end up. And the company may have a name on the patent, there may be a description in the patent, just kind of a high-level description, and they're like, yeah, we have a patent on that. But it turns out by the time that process happened, what they got a patent on was very, very different, very, very narrow perhaps, a very small subset of this kind of general description of the subject matter. And oftentimes the company doesn't even realize it. They just think they've got a patent on, this broad thing that's described in the title and subject matter of the patent. And so you want to understand that a patent is defined by those claims at the end of the patent. All the stuff that comes before it doesn't define exactly what the claims of the patent are. It can illuminate how we interpret the patent language, but the claims themselves define the patent. And so that's where you need to go to understand what this patent document really is saying. Main point here, don't just look at the description, the summary, and even some of the images, the pictures that are in there and go, oh yeah, we have a patent on that. And then you look over to your competitor and say, oh yeah, they're doing that. And then send off a cease and desist letter like we talked about in the trademark realm and get into another problem on the patent side now. You need to understand exactly the scope of it so you can understand, do we really have a patent? What is it on? How good is it? How bad is it? What are our problems? And that's a very complicated process that you really at that point probably need to get patent prosecution lawyers in to look at and help educate you and illuminate you. Now, the backstop to patents, of course, are prior art and obviousness. And this means that, in order to have a patent, it has to be something that's, not obvious. And if it was obvious, or if there are prior art already describing it, then you cannot get a patent on it. And so these are the standards for patentability in terms of prior art and obviousness. And this comes from the Patent Act, 35 U.S.C. 102 for prior art, and it says novelty, prior art. A person shall be entitled to a patent unless the claimed invention was patented, described in a printed publication, or in public use, on sale, or otherwise available to the public before the effective filing date of the claimed invention. 35 U.S.C. 102. And obviousness gets at this in a different way, but what it says, and this is 35 U.S.C. 103, a patent for a claimed invention may not be obtained, notwithstanding that the claimed invention is not identically disclosed as set forth in 102, if the differences between the claimed invention and the prior art are such that the claimed invention as a whole would have been obvious before the effective filing date of the claimed invention to a person having ordinary skill in the art to which the claimed invention pertains. So, in other words, even if there isn't prior art blocking your patent claims, if the claimed invention and the differences between it and the prior art are such that to someone skilled in the art, this whole thing would have been totally obvious to do, then you're not going to be able to get a patent, or you're going to have a hard time enforcing the patent. If you manage to squeeze it out of the patent office, it can be subject to these challenges if you put it into litigation. So let's talk, since we're dropping down into this diligence process as we parachuted into patents here today, on some of the patent misconceptions. And these are things that get you down more at the street level when you're talking to your clients. You want to speak to the employees, the engineers, the designers, the inventors, and have them speak to a patent prosecutor. Much of what they think is no big deal is often patentable, so it could really be a big deal. And so you want them interfacing with the right people so that the right people can double click on what they're saying and tell them, no, that's really good, you can get something. And often you'll find these people who say, oh yeah, it's no big deal. Their minds are blown when they realize, a couple years later, there's a patent issued in their name that's worth 7 figures. If there are inventions or designs that they've been already working on that haven't been sold or disclosed in the last year, then you can still get a patent on that work product, and you want to think rapidly about getting this into the hands of a patent prosecutor. And so one of the tips I would give you is to give your clients protocols for their staff to follow so that they don't publicize certain things they're working on, and so that they consider interfacing with patent prosecutors to figure out if they can get patent applications on file timely. And one of the things you can do, lawyers in my firm do it all the time. They go in-house to companies and, just go give presentations. These are all done free, it's gratis, and there's patent firms all over the country that do this that you'll find. And they'll often go in over a lunch hour and give a tutorial on patentability to all the decision makers and the product designers and the designers in a company to help educate them and illuminate them about what they're doing as it mediates with the patent world so that they can get the best protection possible. The final point to think about is, and I want to loop back to design patents here, is that they have powerful remedies. Design patents can actually get you better remedies against competitors than utility patents. And they're often overlooked in the patent prosecution process. They're kind of the in some sense, the stepchild. Everyone's focused on getting utility patents. But design patents give you the ability to disgorge the entirety of the profits of an infringer, and you cannot get that with a utility patent. The remedies that come from utility patent litigation are much more complicated, much more expert-driven, much harder to get. Design patents can have potent remedies, so it can be a very powerful thing to add if you're pursuing utility patents, to also be thinking about belt and suspenders and get those, or even just get those for certain small companies. So, one good example to think about in terms of how patents can play out in the real world is, and this is sort of where there's a disconnect, companies get patents and they go, oh, done, safe, we got a patent. And what they don't realize is really getting a patent is like getting to first base in a baseball game. That's great, kudos to you. You're a long way from that thing actually being worth something and putting money in your pocket or giving you points if you're talking about litigation. Long way. And so here's just a prototypical case that my partner, Nate Dilger here at 1LP and we litigated many years ago. And and there's nothing special about it or what we did. It's just the way the cases can shake out. And this is a case where we were defending our client. The plaintiff sued on a bunch of issued patents. And this sort of tutorial on this case is to show that the fact that you have a patent isn't good enough. The patent can still be blown up in litigation by lawyers on the defense side. And that's sort of what happened in this case. The adverse party, the plaintiff here was Accuride. They sued our client SSW, and they go into litigation, and ultimately in published decisions by the district court, what happens is the two patents asserted end up being held to have not been infringed by our client, but also to be invalid. And the invalidity of those patents was based upon prior art that had even been considered by the patent office during prosecution. So even that doesn't insulate you just because they've looked at it and it's been disclosed. Courts and juries can still look at it and say, no, this thing is still invalid. And so that helps you understand that to figure out the real value of a patent is very difficult if it's going to require litigation, because litigation can make your patent be worth a heck of a lot less than you thought it was. And if you go like happened here, the patents didn't get invalidated, and now you've got this, what you thought was an asset on day one, at the end of a piece of litigation, it's evaporated. And that is happening all the time in all the courts all across the country. And so patents can have been previously disclosed, and non-disclosed patents can actually impact what is prior art and what can invalidate your patent ultimately. And this can even be foreign language materials. And so you have some quotes from our case where these patents were invalidated, and here's the quotes. Here, defendants have identified several pieces of prior art which allegedly render the patents obvious. The first is, the Dauberstein patent, and this was noted in prosecution. The second, Jarling, noted in prosecution. Finally, the Geberzone patent, was not cited during prosecution. So here we were arguing there's two the patent office considered. You should find it invalid on that reason. And there's one they never even considered. Here it is. But all of those can be used as an arsenal on the defense side. But there's also this issue about an international patent. And so here's the court said, however, an international patent application can also become prior art under 102A, which states that printed publications in foreign countries can be prior art. Section 102A does not require that the publication be in English. And so and it cites In re Hall. This is a Federal Circuit case saying that a dissertation written in German could constitute prior art because it was sufficiently accessible to the public to qualify as a printed publication. And so in our case, using that, we found foreign publications which we were able to use as prior art to invalidate a patent. And that happens all the time too. And that's one of the other misconceptions that one has to be really careful about when you're going to step into being a patent plaintiff in a piece of litigation is you may have done a whole search. Your inventors may have looked at everything, and they may talk to everyone in the field, and they may have all the literature, but they may not know what's being published in Japan or China or Germany in some PhD dissertation or whatnot, which can come back to haunt you. So what are the patent questions that you want to ask? This is our final slide in this module. If there are patents, get the records, make sure the maintenance fees have been paid, make sure inventor and assignments are on file. You want to make sure this thing's in order so it's polished up the best it can be if it's going to go into litigation. If not, you want to go find and see if your competitors have patents, get records on them, and understand what you're doing isn't tripping on someone else. Look for patent license agreements and get potential inventors to your patent prosecutor so they can assess whether you have a patent portfolio to build. Now let's turn to our final module, trade secrets. Trade secrets. Trade secrets are any business information or know-how that derives independent economic value by not being generally known and are subject to reasonable efforts to maintain secrecy. Now, they are sort of the inverse of patents when it comes to registration. Whereas patents only exist if they're registered with the government, trade secrets can never be registered because there is no even registration mechanism. So trade secrets are like copyrights and trademarks in the sense that you don't have to register to get them, but they're unlike patent. They're the inverse of patents in the sense that they can't be registered. There is no registration option. So what are they, and do we have them? Trade secrets cover things such as manufacturing processes, sales techniques, formulas, customer lists, preferences, needs, things that are not known elsewhere. What are the tips to ask your clients? What's your secret sauce? What drives your sales? What drives your profitability? What do you have that others don't have? What's the secret that makes this thing work? What's special? What's unique about how you do your business? So those are the types of gatekeeper questions you want to ask to zero in on, do we have possible trade secrets here that we want to schedule, we want to see as assets? Because if we do, then there is a lot that you can do, that you have to do actually, in order to make sure that you can call these things trade secrets if you need to put them into litigation to protect your company. So the next thing you then do is figure out, what do you do to maintain the secrecy of these things? What do you gain from it? Who knows these secrets? How do you restrict access to them? Do you have written agreements for employees that exist on secrecy? Are there login password protected agreements? This type of stuff. Maybe it's even in the employment agreements. And so you really do want to speak to the IT team, you want to speak to the HR team, and you want to understand what the company does to protect the secrecy of the material that it's creating. And so this is where it becomes very important to interface with the HR people so that you can understand if employees are signing agreements where they acknowledge that the company traffics in trade secrets and has confidential proprietary information and they're going to agree to maintain its secrecy. The IT people can tell you, yeah, our secret sauce is on a server, but it's, there are only 4 people have password, it's all need to know. All of those things have to be done to even reach the point that you can show that you took reasonable efforts to maintain the secrecy of this thing that you want to say has independent economic value by being known by you and only you and not anyone else. So let's talk about a litigation example of this idea of independent economic value. And this is a case that I litigated to the Ninth Circuit twice. I won in the Ninth Circuit twice on the copyright front, but I lost on my trade secret claim. And on the trade secret claim is what I'm going to talk to you about today. And so this was on the issue of independent economic value. And so the basic fact pattern was that you have a vendor working for a large company and it designs a USB device drive for a potential client, and it was a one-off for this potential client, and it was based on the client's pre-existing kind of copyright trademark type design, and so this USB design is being designed. And so it had no use, this sort of design that was being created, beyond this particular use for this particular client, because it was embodying the client's intellectual property. And the client then took the vendor's design to a new company and had a new company make it, and client unhappy, ends up in litigation. And like I said, on the copyright front, we won in the Ninth Circuit a couple times and were able to go to trial on the copyright claim for our client's work, the vendor's work for the client, sorry. But on the trade secret claim that we brought along with our copyright claim, we asserted we had a trade secret in this design, and the vendor said, no, you don't have, the vendor said we had a trade secret, sorry, with my client. The vendor's client, our adverse party, said no, and that was Electronic Arts in this case, you don't have a trade secret because this thing you created had no independent economic value to you. And so this was the core issue that we went up to the Ninth Circuit on. And the Ninth Circuit said, that thing you created, even though you created it, it's your work product, it was your invention, your creation that you made, you can go to copyright. But you can't have had independent economic value in this thing you made not being known to other parties, such as the other vendors who ultimately made it, because it had no potential value to it outside of this single project for a single customer, i.e., if you hadn't sold it to this one customer, you never could have sold it to anyone else anyway, because then it would have been tripping over their intellectual property rights. And so that's an example of where independent economic value has to be something that the company's trade secret has independent economic value if they can exploit it in a whole range of fields. And so that case was reported in the Ninth Circuit at 836 F3rd 1059 in 2016. And so the gatekeeper questions you want to ask are, who knows about this type of intellectual property within the company? And I'll tell you, it's not always a head honcho. It's often mid-level managers, it's people in HR sometimes, people on the front lines of customer interactions. So you want to speak to sales leaders, you want to speak to the content creators perhaps in the company doing marketing and internal content creation. You need to speak to the IT people to understand how this information that's a secret is being managed and how it's flowing and who can see it. Is it being treated like a secret? Because if it's not being treated like a secret, the court's going to have a hard time treating it like a secret for you. You want to understand who manages the IP transactions in the company so you can get a record of those to understand if there's a record of things being asserted or levied or charged or scheduled as trade secrets. And of course, human resources, because you need to make sure this stuff is in employee agreements or independent contractor agreements too. And if it's not, put it in there. And remember, if it's not an independent contractor agreement, don't forget our first module, copyrights, put the right stuff in there too. And fundamentally, and finally, who manages existing IP registrations? You want to get all the documents and you want to check yourself at the Copyright Office and the Patent and Trademark Office to make sure you have assignments, maintenance fees, and all that for all IP registrations, because a lot of this IP that you've registered may be tangentially related to, or it may abut what are other aspects of it that are trade secrets that may not have been registered as patents or copyrights, but are attendant to it, and they can exist as trade secrets. And you want to understand if there is an overlap potentially, is there something that's been published to the world that would undermine the idea that this could be a trade secret separately? And so often trade secrets and patents go hand in hand because there's kind of manufacturing processes and know-hows that are trade secrets, and there's similar things in patents. And so you want to be careful that you make sure that this line between what's secret and not known and what's published to the world in a patent, you don't trip over the line and blur it. So this brings us to our conclusions and our tips for you as you're doing your IP transactional work for clients in due diligence. Number one, don't assume there's no intellectual property there just because the company's people say there isn't. Much valuable intellectual property across all 4 areas we've talked about. It can exist and it may not be known to exist because of misconceptions by businesses about even what intellectual property is and what it could be and what it could protect. The flip side also is to be careful. Just because clients tell you, oh yeah, it's a secret, don't assume it is. You have to peel that onion back heavily. I've had endless number of examples of clients telling me they have really important trade secrets, they're secrets, and as you peel back layers and layers to the onion, you realize they've done nothing to treat it like a secret. It's not a secret, and you could never sue on it as a secret. Number 2, get the employees, independent contractors, make sure they're locked down properly on the copyright front and on the trade secret front with the right agreements. Number 3, for the trademark side and also the copyright patent side, make sure that you lock down proper evidence. If it exists, you preserve it. If there's an Instagram channel and people are showing confusion and that stuff's going to disappear off Instagram in 6 months or Snapchat or whatever, preserve it. Tell your clients to preserve evidence of confusion by consumers so that you can protect yourself. Number 4, check the license agreements on all IP so you can understand the limits of what you're doing, what you can do, what you cannot do, so you don't trip over something, or so that others don't trip over your rights. And finally, remember, if you're dealing with copyrights and trademarks that may exist, that do exist, think about registration if it hasn't been done to get the maximum amount of benefits you can from the litigation system so that those assets can have the greatest value possible. As always, if you have any questions, please email me. Thank you.